Preston
You're a
arrived at the
liar.
courthouse at
You knew what you were
8:47
doing.
with 4 attorneys, 2 paralegals, and the specific expression of a man attending something he considers beneath his calendar. His lead counsel, a senior partner from the firm that had handled Apex Systems' legal work for 9 years, had told him the previous evening that this was a formality, that the plaintiff's attorney was a solo practitioner with limited resources, that the case hinged on a timeline that they had documentation to contest, and that by noon, the most likely outcome was either a directed verdict in their favor or a plaintiff's settlement under the terms they had already offered twice. Preston had nodded. He had been to enough board meetings to understand when a senior partner was managing his anxiety rather than assessing the situation. He had chosen, this time, to believe the assessment rather than interrogate it. He regretted this at 9:14. He regretted it specifically when Deshaun Carter stood up. Preston had seen Deshaun across the aisle when they entered, had registered him the way you register something that does not fit the expected picture, and then moved on. He was younger than Preston expected, bigger than Preston expected, and alone at the plaintiff's table with a single yellow legal pad and a manila folder, while Preston's table had 4 attorneys and 2 paralegals, and a case cart with 6 bankers' boxes. The disparity had seemed, to Preston's lead counsel, favorable. To Preston, in retrospect, it should have seemed like something else. Deshaun stood up and said, "Good morning, Your Honor." He said it with the specific economy of someone who does not need preamble. He said, "I'd like to call my first witness." Judge Alderton said, "Proceed." The first witness was a former Apex Systems IT administrator named Gerald, who had left the company 4 months after Carla Reyes. Deshaun asked him 12 questions. The questions were specific, sequential, and built from each other with the structural precision of something that had been constructed over 6 months, not the theatrical questioning of someone performing for a jury, but the functional questioning of someone building a foundation that nothing that came after would be able to stand on without acknowledging. Preston's lead counsel objected 3 times. Judge Alderton sustained 1 objection and overruled 2 with the brisk efficiency of a judge who has heard these objections before and has already decided how they land. By 9:53, Gerald's testimony had established 3 things: that Carla Reyes had reported the financial irregularities to her supervisor 17 days before her termination, that the supervisor had forwarded the report to Preston's office within 24 hours, and that Preston's office had responded with an email marked for the attention of the legal department. Preston's lead counsel leaned to him and said very quietly, "We're going to need to adjust the timeline argument." Preston said, "I thought we had documentation." His lead counsel said, "We do. I need to look at it again." Before we continue, if you believe that preparation is the only kind of power that cannot be bought and cannot be faked, please like this video, subscribe to Stillwater Stories, and share this with someone who needs to believe in people again today. Deshaun's second witness was a data forensics expert who had spent 4 months analyzing the metadata of 14 internal Apex Systems documents. She testified for 40 minutes. Deshaun asked her 31 questions, each one precise, each one arriving in sequence, the whole thing with the quality of a piece of music that had been composed rather than improvised. Preston's lead counsel cross-examined for 22 minutes. The cross-examination did not go well. It did not go badly in a dramatic way. There were no moments of collapse, no confessions, nothing cinematic. It went badly in the specific way that good cross-examination fails, quietly, incrementally, with the witnesses' answers remaining consistent while the questions became less focused and the attorney's rhythm became less certain. Judge Alderton called a recess at 11:30. In the corridor, Preston's lead counsel said, "I want to have a conversation about the settlement offer." Preston said, "You told me last night." He said, "I know what I told you last night. I'm telling you something different this morning." Preston looked at the courtroom doors. He said, "How bad is it?" His lead counsel was quiet for a moment in the way lawyers are quiet when they are calibrating honesty against client management. He said, "The timeline issue is significant. The metadata is, it is going to be difficult to contest. And his closing argument is going to put the email from your office in front of the jury and ask them one question. Preston said, "What question?" He said, "Whether you knew." Preston said nothing. He said, "The answer doesn't matter as much as the question. Juries don't like the question." Preston looked at the corridor, the fluorescent lights, the marble floors, the ordinary institutional authority of a courthouse that had been processing justice of various qualities for 40 years. He thought about the settlement offer. He thought about what Carla Reyes had lost, the job she had held for 6 years, the salary, the health insurance for her 2 children, the 8 months of legal practitioner that a solo practitioner had carried on a contingency basis because he believed the case. He said, "What did we offer her?" His lead counsel said, $200,000, with an NDA. Preston said, "What does she make? What did she make?" He said, $87,000 a year. Preston said, "We offered her 2 years' salary to sign away her voice." His lead counsel said, "It was a standard." Preston said, "I know it was standard." He stood in the corridor for a moment. Then he said, "I want to talk to their attorney." His lead counsel said, "Preston, I don't think..." Preston said, "Not to negotiate. I want to talk to him." He walked back to the courtroom. Deshawn was at the plaintiff's table, reviewing his legal pad. Carla Reyes was beside him, a cup of water in front of her, looking at the middle distance with the expression of someone who has been waiting 8 months for something and is not going to stop waiting now. Preston approached the table alone, without his lead counsel, without his paralegals, without the 4 attorneys who had arranged themselves around him all morning. He stood at the edge of the plaintiff's table. He said, "Mr. Carter." Deshawn looked up. His expression did not change, neither hostile nor warm, simply present, the face of someone who was not going to perform a reaction. Preston said, "Can I speak with you? Not about settlement terms. I just want to talk." Deshawn looked at Carla. She looked at him. He said, 5 minutes, without your counsel." They stood by the window at the far end of the courtroom. Preston said, "How long did you prepare this case?" Deshawn said, 6 months. Preston said, "You were offered a settlement twice." Deshawn said, "My client was offered an insult twice." Preston said, 200,000 is not. Deshawn said, 200,000 is 2 years of salary and silence. He said it without heat. 6 years of her career, her health insurance during which one of her children had a significant medical event, her professional reputation which your company's termination documentation described in terms that made her difficult to rehire. And her voice. He paused. The NDA would have taken her voice. Preston said, "I didn't write the NDA." Deshawn said, "I know." He looked at Preston with his dark, serious eyes. "You didn't write the termination documentation either. You didn't make the call to legal." He paused. "But your office got that email on a Friday, and she was terminated the following Friday, and nobody in your organization has been able to explain the coincidence." Preston said, "Are you giving me the closing argument?" Deshawn said, "I'm giving you the facts. The closing argument has more adjectives." Preston was quiet. He said, "What does she actually need?" Deshawn looked at him for a moment, the same assessment Mia had given Ryan, the same head tilt of someone deciding whether to believe a question is sincere. He said, "Her job back, which is not possible because the position no longer exists. So, equivalent placement in a comparable role with documentation that restores her professional record. Full back pay for 8 months. Medical costs for her daughter's treatment during the gap in coverage, and a public statement from Apex Systems that the termination was in error." Preston said, "The public statement," Deshawn said, "is non-negotiable." Preston said, "My board," Deshawn said, is going to be significantly more concerned about what comes out in the next 2 hours of testimony than about a public statement. Preston stood by the window for a moment. He looked at Carla Reyes across the courtroom, sitting beside the empty plaintiff's chair where Deshawn had been, her dark eyes forward, her posture exactly what it had been all morning. 8 months of that posture. 8 months of sitting straight and waiting. He said, "Give me a number." Deshawn said, "I already did." Preston said, "I mean a full number, everything, appropriate compensation, not just make whole." Deshawn looked at him. He said, "Why?" Preston said, "Because I just spent 3 hours watching you build something that took 6 months to construct, and the only reason it needed to be constructed is that my company did something wrong, and then my legal team tried to make the wrongness efficient." He paused. "I'm tired of efficient wrongness." Deshawn said, "That's a significant thing to say." Preston said, "I know. I need you to tell me if it's enough or if I need to say it somewhere it's on the record." Deshawn looked at him for a long moment. Then he said, "I need to talk to my client." He went back to Carla. Preston watched from the window. He could not hear the conversation. He watched Carla's face as Deshawn spoke, the careful stillness of it giving way, incrementally, to something that was not quite relief yet, but was in the direction of it. Deshawn came back. He said, "She'll settle on the following terms." He recited them, the placement, the back pay, the medical costs, the public statement, and one more item that he had not mentioned before. He said, "She wants it in the record that the original report she filed was accurate, that the financial irregularities she identified were real." Preston said, "Were they?" Deshawn said, "Our forensic accountant says yes." Preston said, "Mine does too." Deshawn looked at him. Preston said, "I know. I should have said that 8 months ago." He went back to his table. He spoke to his lead counsel for 6 minutes. His lead counsel's expression went through several stages, the last of which was the specific expression of a senior partner calculating how this changes his firm's relationship with its largest client, and concluding that the client has decided something that is not going to be changed. Judge Alderton returned from recess at 12:14. Deshawn stood and said, "Your Honor, the parties have reached a settlement agreement." Judge Alderton looked at both tables. She said, "Let the record reflect that the settlement was reached after the presentation of the plaintiff's case." She looked at Preston. She looked at Deshawn. She said, "Is the agreement complete?" Deshawn said, "It is." She said, "Then we're adjourned." She gathered her materials. Before she stepped down from the bench, she paused and looked at Deshawn for a moment. The look of a judge who has been in this room for a long time and is recognizing something worth recognizing. She said nothing. She stepped down. Deshawn sat down beside Carla. He put his yellow legal pad on the table. He put his pen on top of it. He looked at his client. She said, "Is it enough?" He said, "The financial settlement is what we discussed. The public statement will restore your professional record. The acknowledgement that your report was accurate." She said, "Is it enough?" He understood the question. He said, "I think it is. I think today is enough." She put her hand over his on the table. She did not say anything else. Preston left the courthouse at 12:41. He stood on the steps for a moment in the March light, his lead counsel beside him, the 4 attorneys behind him, the case cart being wheeled to a car at the curb. He looked at the courthouse door. Deshawn came out 10 minutes later with Carla beside him. Preston was still on the steps. Their eyes met across the courthouse steps. Neither of them moved for a moment. Preston said, "Mr. Carter, you were ready for things my team wasn't." Deshawn said, "I prepared." Preston said, "For 6 months, on contingency." Deshawn said, "She deserves someone who would prepare." Preston looked at him. He said, "You turned down corporate offers." Deshawn said, "How do you know that?" Preston said, I had my team pull your background when we learned you wouldn't settle. Deshaun said, and? Preston said, top of your class. 3 offers from firms that would have paid you 4 times what you make. Deshaun said, 5 times. He said it without bitterness, simply accurate. Preston said, why? Deshaun said, because Carla Reyes needed someone who would prepare for 6 months on contingency. He paused. The firms that offered me 5 times the salary were not going to assign me to Carla Reyes. Preston was quiet for a long time. Then he said, if I had hired you 8 months ago to look at the internal report, what would you have told me? Deshaun said, that the irregularities were real, that the termination was legally and ethically indefensible, and that settling early with fair terms would have cost you 1/10 of what today cost you. Preston said, I should have asked. Deshaun said, yes. Preston said, would you have taken the call? Deshaun looked at him. He said, from you directly? Yes. From your legal team? No. Preston said, why the difference? Deshaun said, because your legal team's job is to manage your exposure. My job is to tell the truth about what I see. Those are different conversations. He extended his hand. Preston shook it, Deshaun's large, powerful hand around his, firm and brief, neither of them making it more than what it was. Deshaun went down the steps with Carla. Preston watched them go. His lead counsel said something beside him, something about next steps, about the documentation, about the public statement timeline. Preston nodded without listening. He was watching Deshaun and Carla at the bottom of the steps, Deshaun saying something to her, Carla listening, and then the very small, very specific thing that happened in her face after he finished saying it. The thing that 8 months of waiting and 1 morning in a courtroom had finally made possible. He had spent 2 hours watching someone outclass his room. He had spent another hour understanding why. He was going to spend considerably longer understanding what to do with that. His lead counsel said, Preston, the car is... He said, I need a minute. He stood on the courthouse steps in the March light and thought about what Deshaun had said, that Carla Reyes deserved someone who would prepare. That preparation was the thing that had been on the other side of the aisle. Not 4 attorneys, not 6 bankers' boxes, not 9 years of institutional relationship. 1 yellow legal pad, 6 months of work, and the specific courage of someone who had looked at the case and decided it was worth preparing for. He got in the car. He told his lead counsel he wanted to speak to the Apex Systems board about their internal reporting protocols. His lead counsel said, in what capacity? He said, in the capacity of someone who should have listened to a report 8 months ago and didn't. He paused. I want to fix the thing, not just the settlement. His lead counsel said nothing. Preston looked out the car window at the courthouse receding behind them. He thought about a yellow legal pad, about a question the jury never had to hear because he had answered it first. He had been wrong about what room he was in. He was starting, finally, to understand what room it actually was. If this story moved you, please like this video, leave a comment, and share it with someone who needs to hear it today. Subscribe to Stillwater's Stories for more stories of courage, grace, and the small human decisions that turn out to matter more than anyone knew. And tell us in the comments, have you ever watched someone outclass a room that thought it couldn't be outclassed?